I am going to talk about the topic that was just advertised. I'm not making a switch in midstream, and I'd like to ask your forbearance while I do initially what I think is a more analytical treatment of this topic so that I can use that as the basis for the policy implications. And it's really the policy implications or recommendations that I'd like to emphasize with you today. For a period of time, the idea of contract in U.S. employment relations was predominantly manifested by collective bargaining agreements negotiated between representatives of unionized employees and companies, representatives of company owners, managers. At their peak, these agreements covered only about a third of the U.S. workforce, but they often set benchmarks for and spilled over to affect terms and conditions of employment for non-union employees, including supervisors and managers. So during that period, largely mid to third quarter 20th century, employment contracting basically meant collective contracting. And this was, of course, no accident. The 1935 National Labor Relations Act, the Wagner Act, expressly supported private sector collective bargaining as public policy, a policy that continues in place despite numerous amendments to the Wagner Act, the subsequent sharp decline in private sector employee unionism, and continuing controversy over the role and function of the National Labor Relations Board in administering this law. And though scholars have long debated the exact reasons for that rapid union growth during that period, beyond the fact of just the Wagner Act, there is little doubt that collective contracting was the dominant way in which terms and conditions of employment were set and codified for millions and millions of employees, and there was no doubt that those employees had collective voice. Now, accompanying this particular phenomenon was another, namely the implicit employment contract. So by definition, not written, not publicized, and the terms of that implicit contract, however, were pretty clear. An individual, typically a man, joined a company, could work there for a lifetime, retire from that company, and receive a defined benefit type of pension plan income after retirement. Early on, that person would be paid less than the value of their performance or productivity. Later on, more than the value of their performance or productivity. And that helps us explain why we had this long-term employment contracting. There was an obligation of one party to the other along that particular career path. And such implicit contracting was also reflected in layoff and recall provisions of collective bargaining agreements, meaning that even during recessions, the dominant presumption or implicit contract was one of continuous employment with the same employer. Today, on the occasion of the Labor and Employment Relations Association's 65th annual meeting, private sector employment contracting and long-term implicit individual employment contracting are in decline, substantial decline, and are considered by some to be relics of the past. How much of a decline, I probably don't need to spend much time on with you. Last year, according to our DOL data, of a private sector workforce of approximately 110 million, 93.4% didn't belong to a union, and 93% were not represented by a union. And this development has occurred despite examples taught as real cases in real academic programs and elsewhere of highly unionized companies that are financial performance leaders in their respective industries. As examples, Southwest Airlines, Willamette Industries, Boeing Corporation. And despite research on mutual gains negotiations, a lot of that done by some people in this room, that analyzes and documents the benefits that accrue to unionized employees, management, and other constituents from such cooperative, integrative bargaining. Among the U.S. private sector workforce, the incidence of long-term employment with the same employer continues to decline, as does coverage by defined benefit pension plans. So if we add to that the fact that newer, younger labor force entrants, those people in high schools in particular, expect to change jobs often and to be employed by several different employers during their careers, the inescapable conclusion is that the labor market is becoming more of a short-term spot or commodity market and less of a long-term, institutionally based or governed labor market. In light of these developments, it appears, therefore, that individual voice in the employment relationship is the only option for most private sector employees. But is it? The answer to this question is no, based on research and practice in two areas: non-union employee representation and so-called strategic human resource management. NER research indicates that a majority, perhaps a large majority, of non-union U.S. companies have adopted one or another type of internal employment conflict resolution system or procedure, and these various procedures are often subsumed under the label alternative dispute resolution. The word alternative is particularly instructive because if you have it in a title, it has to be alternative to something, and the alternative here is either to unionization or to litigation over employment-related disputes. To the extent that internal ADR procedures are adopted by non-union companies to ward off employee unionization, they can be linked to external human resource regulation, for example, the Civil Rights Act, the Occupational Safety and Health Act, the Employee Retirement Income Security Act, and the Family and Medical Leave Act, to provide a combined micro-macro level dual substitution explanation of the decline in U.S. private sector employee unionization. Now, in contrast to this NER work, or NER and ADR work, the research in strategic human resource management, SHRM is the acronym, emphasizes a proactive approach to employment relationship conflict featuring various employee involvement and participation systems and practices. Most of the time, employee consultation teams, online, offline, are amongst these practices. And a subset of these so-called high involvement human resource management systems include an internal dispute resolution procedure. The research evidence, the empirical evidence, tells us that the existence and availability of such a procedure for non-union employees, together with these other so-called high involvement practices, is significantly associated with, positively associated with organizational performance. But the actual use of the procedure is significantly negatively associated with financial performance. Hence, in other words, from an organizational performance perspective, an internal ADR procedure is best when it is not used. Nevertheless, the evidence and marked growth of such procedures tells us that there is an alternative institutional mechanism to unions and collective bargaining that potentially provides voice or quasi-voice for employees who operate under those practices. Now, an accompanying development that essentially provides voice to employees is the explicit individual employment contract. And trying to estimate the extent to which such contracting prevails in the U.S. is pretty tricky because there is no, I could find no extant database or systematic collection of these kinds of data. But there is little doubt that it is a pervasive arrangement. In financial services, for example, employees sign agreements specifying that as a condition of employment, any employment relationship dispute that arises later on is going to be resolved through arbitration. Very similar to the type of agreement signed by customers of financial service companies. Explicit employment contracts, individual contracts like this, are increasingly common in other industries and sectors, high-tech, telecommunications, and retail trade as examples. It's therefore likely that tens of millions of employees in the U.S. are covered by explicit individual employment contracts. And as many of you in this room would know, such contracts have become even more widespread due to a series of U.S. Supreme Court decisions invoking what is in essence a deferral to arbitration doctrine in the cases of non-union employment relationships disputes. Those cases are almost an identical match to the Steelworkers Trilogy in the 1960s, articulating the same doctrine in unionized contexts. By doing so, these contracts mitigate the litigation threat in particular, and we know that employer-initiated dispute resolution arrangements tend to work in favor of employers because they tend to dominate in the selection of arbitrators, in the specification of the scope of issues that are covered by arbitration, in paying arbitrator fees, and the rest. At the other end of this spectrum, so to speak, are individual employment contracts. Think of it at the top. These contracts increasingly prevail for executives and managers of U.S. companies, whereas executive and senior management labor markets were once characterized by strict adherence to the employment at will doctrine and handshake agreements, it's become increasingly common for executives and senior managers to be employed under terms and conditions spelled out in formal employment contracts. In executive ranks, these are called executive contracts. They are negotiated, these contracts are, not by the individuals. They are negotiated by their agents, representing senior managers and executives, and they negotiate those with company representatives. This is very similar to what occurs in much of the entertainment industry, specifically in theater, film, television, and professional sports. You have to understand, these executive contracts are quite comprehensive. They often provide for signing bonuses in cases of external hires. They provide for deferred compensation. They provide for additional compensation if a change of control occurs, typically through a merger or an acquisition. And they, in particular, provide severance payments if executives are, quote-unquote, separated. They may also contain provisions under which an executive or a senior manager can challenge certain decisions of other executives or a board of directors. And I think this is the leading contemporary example of explicit individual employment contracting and individual voice in the labor market and employment relations. When you take all of this individual employment contracting into account, from the bottom to the top, the contracts cover many more employees than are covered by collective bargaining agreements. The multiple in this regard might be on the order of 5 to 6 times. What's more difficult to estimate is the extent to which employees covered by these contracts actually exercise individual voice and the extent of the issues, the scope of the issues over which they can do so. My own judgment is that employees holding lower and middle-level jobs have a relatively narrow scope of individual voice, whereas senior managers and especially executives have a relatively wide scope. And this inequality is closely parallel to the rising inequality of compensation between executives and employees of U.S. companies that is typically explained by tournament theory. Another different example of individual contracting for labor services is provided by so-called independent contracting. Now, unlike previous examples, this type of contracting does not involve an employment relationship. In fact, independent contracting is a substitute for it, a substitute for employment and employment contracting. And it's been widely adopted by U.S. companies in such industries, especially as transportation and telecommunications. So consider, for example, a company such as Federal Express, which is essentially a holding company composed of several so-called strategic business units. One of these units is FedEx Express, which delivers packages and related items to businesses. Delivery drivers of it are employees. In another business right next to it on the FedEx organizational chart, FedEx Home and Ground System, stuff delivered to you at home. The person who delivers those packages is an independent contractor. The two sets of delivery drivers perform exactly the same job tasks and services. However, the former, who are non-union, are nevertheless covered by FedEx's NER system, the Guaranteed Fair Treatment System, whereas the latter, the independent contractors, are not. And both of these practices contrast with the collective voice that's exercisable by FedEx pilots who are unionized and whose terms and conditions of employment are set through collective bargaining. FedEx is hardly alone among U.S. companies in maintaining these multiple arrangements for labor services. It's not just a question of union v. non-union or employment versus independent contracting in a company. You have to go inside of a company to see what its units are actually doing. The concept of an independent contractor is equivalent to that of a vendor who can presumably choose to whom to sell products and services. But how independent are independent contractors? In the FedEx example, the contractor can only provide services to FedEx, no one else, can only deliver the packages and related items assigned to them by FedEx, deliver only to FedEx specified customers, and drive only the routes specified by FedEx. Those independent contractors are closely managed by terminal managers. They must follow the operating rules and procedures specified by FedEx. The terminal manager's job is to ensure that they do so. The terminal manager evaluates their performance. The independent contractor drivers can be disciplined by FedEx, including cancellation of their contracts for violating company operating rules and procedures. And while independent contractors can protest disciplinary actions taken against them and challenge their performance evaluation, they otherwise are not able to exercise collective or individual voice in their independent contracting relationships with this company's home and ground unit system in the way that employees of FedEx Express and Kinko's and others are able to exercise such voice. Now, before turning to policy implications, there's one other type of labor contracting arrangement I want to call to your attention, which is known as deputing, D-E-P-U-T-I-N-G. To illustrate, a company like Tata, T-A-T-A, the India-based corporation, it recruits and trains hundreds of thousands of individuals annually and then deputes them to the United States, where they perform labor services for companies. These are very largely large Fortune 500 companies with a tilt towards the Fortune 100. The services provided in this respect by these trained individuals are typically technical and analytical in nature, code writing, software development, systems analysis, and that sort of thing. Deputation assignments can last up to 3 years, during which time the companies for which such services are performed pay a contract price to Tata. In some instances, these companies do not directly pay or provide fringe benefits to the individuals performing these labor services. And correspondingly, they don't pay payroll taxes to state governments and the federal government for the performance of those labor services. In other instances, they do compensate deputed employees directly. However, disputes have arisen, substantial disputes, over the national jurisdiction, the US or India, to which taxes on such earned income should be paid. Although the extent of such deputation arrangements is unknown, it's likely to involve several million individuals who perform labor services for the U.S. companies to which they are assigned. And more to the point, for the purpose of this presentation, these individuals are unable to exercise collective or individual voice in their non-employment or quasi-employment relationships with U.S. companies. Given all of this, it's especially pertinent to LERA members, I hope, to ask whether new public policy initiatives should be adopted to more closely regulate labor market and employment relationship contracting. If one supports the basic intent of the NLRA and certain other employment or human resource regulation, which was to mitigate, if not fully offset, unequal bargaining power between company management and employees, then the answer to this question is yes. Or yes for most but not all types of employees. If one supports the trend towards spot or commodity type labor markets and employment relationships, then the answer to this question is no. Or no for most but not all types of employees. Following the first position, the U.S. should adopt basic employee rights legislation, minimum standards legislation, that includes provisions for employee voice. So this means that an employee who has a dispute with his or her employer should be able to bring that dispute to the attention of the employer, either verbally or in writing, without fear of reprisal. If such a dispute is quickly or eventually taken up in arbitration, the employee or employee's representative, together with a representative of management, should jointly select the arbitrator. The costs of arbitration can be borne or paid for in several ways. One is to expand the Federal Mediation and Conciliation Service, the FMCS, and I have a couple of acronym changes in this section to note for you, to the Federal Mediation, Conciliation, and Arbitration Service, which would provide arbitration services for all private sector employment disputes and be paid from general fund tax revenues. That is the FMCAS, no longer the FMCS. Another way is for private employers to purchase broad-based or generalized employment dispute resolution insurance, much in the same way that private employers presently purchase insurance to cover the costs of particular types of disputes involving, for example, allegations of discrimination, or in the way that they purchase insurance to cover the loss of key executives. Another arrangement would require employee disputants to pay a portion of arbitration costs, especially to mitigate frivolous employment dispute claims. Furthermore, new employee rights legislation should not be limited to employees per se, but instead should apply to or cover those who work as independent contractors and deputed personnel. Following this reasoning, almost anyone who provides labor services to a company and who experiences a work, but not necessarily employment-related dispute, would be eligible to invoke a minimum standards dispute resolution procedure and thereby exercise voice. I use the qualifier here because it is unclear whether and to what extent such new legislation would apply to customers of companies who increasingly provide technologically enabled unpaid labor services. So those of you that bought your airline ticket online and downloaded your boarding pass online, you just finished providing substantial unpaid labor services to the particular airline you used. And the examples multiply dramatically, but we have no systematic database about the extent of unpaid customer labor usage yet. This proposed new employee rights legislation would not apply, that is, it would exclude employees holding executive and senior management positions in companies. The underlying reason for this exclusion is grounded in risk, reward, and organizational control concepts and evidence. Let me summarize that by saying that that evidence and that underlying conceptualization presumes that executives and senior managers accept such positions knowing they're accompanied by substantially greater compensation than they previously earned, but also by potentially greater risks than they previously encountered. The higher compensation in effect incorporates or reflects this higher risk, including the risk of termination if the companies that employ them underperform. Furthermore, it is these executives and senior managers who control the strategies and decisions of companies that fundamentally affect employment and employment relations for millions, tens of millions of non-executive, non-senior managers. And so in this regard, and based on agency theory and research, company executives and managers are far better able to serve and protect their particular interests than our non-executive, non-senior employees. Add to this the executive contracts and senior management contracts they've been able to negotiate, they can protect themselves very well. While new private sector employee rights legislation of the type I'm proposing could be added to the current inventory of U.S. labor and employment workplace laws, labor, employment, and workplace laws, an alternative is to replace those laws with an overarching employee rights law. So if you consider that the National Labor Relations Act, the FLSA, the Civil Rights Act, Section 7, the Fair Labor Standards Act, the Age Discrimination and Employment Act, the OSHA, the Employee Retirement Income Security Act, and the Family and Medical Leave Act, just to take a few, all focus on and regulate one or another aspect of private sector employment and employment relationships. Obviously, this piecemeal approach is not derived from an overall grand plan or design. To the contrary, each of these statutes was enacted to address a particular issue or problem that was thought to be worthy and correctable by the legislation. But this kind of partial approaches, or partial equilibrium, if you like, partial approach to employment and employment relations regulation is increasingly unsuitable to modern times and tend to reflect what scholars typically characterize as path dependence. So following a systems approach to this issue, a new comprehensive overriding law would regulate private sector employment relationships and labor services arrangements throughout the U.S. The law would specify basic rights attached to the employment relationship, including those pertaining to non-discrimination, workplace safety, leave from work, minimum pay, minimum wages, overtime, retirement income, and employee voice, including through unionizations and other channels. Under this law, all types of work would be covered, including work performed electronically and otherwise from home and additional locations. These basic rights would apply as well to independent contractors and those who provide labor services through deputed work. Further, this new employee rights law would override or supplant individual state laws that apply to one or another aspect of private sector employment relationships, and which are often used as estate patches. It would also consolidate or replace the various agencies that presently oversee and administer issue-specific laws with a superagency that would operate under the auspices of the U.S. Department of Labor, or, my preferred choice, under the joint auspices of the Department of Commerce and Department of Labor, which would reflect a mutual interest approach to regulation and give the Department of Commerce a chance to have its acronym widely used. Has anyone ever heard of the DOC? No, but you have heard of the DOL. And I'm actually quite serious about this proposal. If one believes that the new comprehensive private sector employee rights legislation of the type I've outlined is not needed, and you can believe that, that belief is likely based on the view that there's no market failure at work in this regard, or in other words, that employers and employees should be completely free to choose. This view, that view, is consistent with neoclassical microeconomic theory, the assumptions of full mobility, perfect information, and equilibrium, and with the pure theory of political democracy. It's even more fundamentally applied, that view is, to product markets in which vigorous competition among firms to supply goods and services demanded by customers is regarded as yielding maximum individual utility, which when cumulated yields the greatest good for the greatest number of people in the society. But as we know, this theoretically driven view is belied by the history of regulation of both product and labor markets in this country. Historical examples, speaking of history, as the Sherman Antitrust Act, the Food and Drugs Act, the Securities and Exchange Act, and the National Traffic and Motor Vehicle Safety Act, as well as contemporary examples, the Sarbanes-Oxley and Dodd-Frank Wall Street Reform Acts, to take recent ones, indicate that we have consistently used regulation through legislation in the product markets, to regulate product markets. Similarly, and as you all know well, labor markets and employment relations have long been the subject of national regulation, with such regulation perhaps bookended by the NLRA and the Social Security Act on the one hand, and portending new immigration legislation on the other hand. So this brief consideration of product and labor market regulation indicates that the concept of fairness or justice competes with the concept of economic utility maximization as a dominant societal value. In the area of employment relations, this is attested to by extant research on organizational justice, much of which has been conducted by organizational behavior scholars and some by industrial relations scholars. A key finding, perhaps the key finding from this research, is that employee perceptions of the overall fairness of their employment relationships is more strongly influenced by their perceptions of procedural justice than by their perceptions of distributed justice. The former refers to the processes through which decisions are made, and the latter therefore refers to the results or outcomes of those decisions. To illustrate, if employees perceive that the processes through which their pay, benefits, work schedules, working conditions, and other aspects of employment are determined, are basically fair, they will perceive overall organizational justice to be high or strong, even if they perceive the outcomes of one or more of these decisions to be relatively unfair. When you take these empirical findings and combine them with findings from research on unionism, collective bargaining, NER, ADR, and SHRM, they underscore that the employment relationship is only partly about pay and work. It is also partly about fairness or justice, which may be the more salient, meaningful part of the employment relationship. This reasoning helps us to understand why the employment relationship has so frequently been the subject of regulation, and why new, more comprehensive, smarter regulation of U.S. private sector employment relationships may be required. I'm going to conclude by saying that this line of reasoning also helps us to understand why an earlier generation of scholars and practitioners, that's both, created the Industrial Relations Research Association, the IRA. They believed that the employment relationship was not simply another market transaction, but instead a special relationship that required specialized analysis and specialized public policy treatment. 65 years later, that fundamental belief in the importance and necessity of voice in the employment relationship remains as strong and compelling as it did then, even as U.S. private sector employment relationships and voice arrangements have changed markedly, and as the LERA faces new and continuing challenges to its mission, purpose, and vitality. It's therefore critical for employment relations researchers, especially those who belong to the LERA, to bring their best efforts, their very best efforts to bear in studying and offering policy recommendations regarding new employment contracts and relationships of the type that I've spoken about here today. Thanks very much.